Eminent Domain. Concept of Eminent Domain. Section 9, Article 3. Private property shall not be taken for public use without just compensation. The power of eminent domain is the inherent right of the state to forcibly acquire needed property upon just compensation in order to devote it to the intended public use. It's also called the power of expropriation. Section 9, Article 3 merely imposes a limit on the government's exercise of this power. Republic v. Tagle, 1998. The exercise of the right of eminent domain, whether directly by the state or by its authorized agents, is necessarily in derogation of private rights. The authority to condemn is to be strictly construed in favor of the owner and against the condemner. When the power is granted, the extent to which it may be exercised is limited to the express terms or clear implications of the statute in which the grant is contained. National Power Corporation v. Tarcello, 2014. Who may exercise eminent domain? The repository of eminent domain powers is legislature, that is, exercised through the enactment of laws. But the power may be delegated to the LGUs and other government entities via their charters. Still, the delegation must be by law. The case of Manapat v. Court of Appeals. Under existing laws, the following may exercise the power of expropriation. 1. Congress. 2. President. 3. Local legislative bodies. 4. Certain public corporations like the National Housing Authority and water districts. From the case of Metropolitan Cebu Water District versus King, 2009. And 5. Quasi-public corporations like the Philippine National Railways or PNR, PLDT, and Meralco. What are the requisites for valid exercise of eminent domain? 1. Private property. 2. Genuine necessity, or the inherent or presumed in legislation, but when the power is delegated, such as in the case of local government units, necessity must be proven. 3. For public use. Court has adopted a broad definition for public use. 4. Payment for just compensation. And 5. Due process. From the case of Manapat v. CA. How is power of eminent domain exercised? Our law requires that the state's power of eminent domain shall be exercised through expropriation proceedings in court. Whenever private property is taken for public use, it becomes the ministerial duty of the concerned office or agency to initiate expropriation proceedings. From the case of Department of Transportation and Communications versus Abisina, 2016. Prior filing of an expropriation case is a condition sine qua non before the government is allowed to enter the property being reclaimed, and without which the government's possession over the subject property becomes illegal. From the case of Secretary versus the Secretary of Department of Public Works and Highways versus Texon, 2015. However, full payment of just compensation is not a prerequisite for the government's effective taking of the property. When the taking of the property precedes the payment of just compensation, the government shall indemnify the property owner by way of interest. From the case of Republic v. Mupas, 2015. The taking of property is different from transfer of the property title from the private owner of the government. From the private owner to the government. Rule 67 of the Rules of Court. It provides for the two phases of expropriation. 1. The condemnation of the property after it is determined that its acquisition will be for a public purpose or public use, and 2. The determination of just compensation to be paid for the taking of private property to be made by the court with the assistance of not more than 3 commissioners. Republic v. Mupas. What are the difference between eminent domain, compensable taking, and regulatory taking? 1. Eminent domain is an inherent power of the state based on the Constitution. Just compensation must be paid. And 2. Regulatory taking is the exercise of the state of its police power. In this case, just compensation need not be paid. Examples from jurisprudence. The imposition of an aerial easement of right-of-way was held to be compensable taking. The exercise of the power of eminent domain does not always result in the taking of appropriation of title to the expropriated property. It may also result in the imposition of a burden upon the owner of the condemned property without loss of title or possession. From the case of National Power Corporation versus Gutierrez, 1991. A municipal ordinance prohibiting a building which would impair the view of the plaza from the highway was considered regulatory taking. From the case of People versus Fajardo, 1958. Expansive concept of public use. What is the traditional definition of public use? It is any use directly available to the general public as a matter of right and not merely of forbearance or accommodation. Where the appropriated property is converted into a plaza, park, airfield, or highway, it thereby becomes res communis and as such is subject to direct enjoyment by any and all members of the public indiscriminately. There is also public use even if the expropriated property is not actually acquired by the government but is merely devoted to public services administered by privately owned public utilities like telephone or light companies. Public use may be free or for a fee as long as any member of the general public can demand the right to use the converted property for his direct and personal convenience. What is the broadened definition of public use? Public use may also refer or cover uses which, while not directly available to the public, redound to their indirect advantage or benefit. Example: subdivision of expropriated lands into small lots for sale at cost to deserving citizens. Once transferred, the lots cease to be public property and come under the exclusive ownership of the transferees. The requirement of public property is deemed satisfied because of the vicarious advantages enjoyed by the people as a whole, by the promotion of social justice objectives, example, equitable diffusion of property ownership, agrarian reform, enhancement of the dignity, welfare, and security of the underprivileged. Examples: expropriation for some clearance and slum development, even if developed area is later sold to private homeowners, commercial firms, and entertainment and service companies and other private concerns. Reyes versus NHA, 2003. Urban law reform and housing or socialized housing program involving only a 1/2 hectare area. Manapat versus CA. Under the new concept of public use means public advantage, convenience, or benefit which tends to contribute to the general welfare and the propensity of the whole community, like a resort complex for tourists or housing project. From the case of heirs of Juancho Ardano versus Reyes and Sumulong versus Guerrero.